All right. Good afternoon.
Good afternoon, Your Honor.
Good afternoon, Your Honor.
Can everyone hear me? If you would, please raise your hand. All right. All right, we'll go ahead and go on the record this afternoon, and we're here in the matter of 21CVS 15, which is the McClatchy Company et al. Versus Terry Johnson and Christy Cole regarding the release of recordings. Let me find for the record. Well, actually, let me ask you to identify yourself, gentlemen, if you would, for the court. Go ahead, Mr. Allen.
Clyde Albright, County Attorney. Ben Pierce, Alamance County Attorney, or Deputy County Attorney.
Thank you. Mr. Tidy. We can't hear you, Mr. Tidy.
I'm Mike Toddy here on behalf of the petitioners.
All right, and who is the other person that I see?
Hello, Your Honor. This is Tony Biller and Adam Banks on behalf of the Graham Police Department.
All right, thank you, Mr. Biller. And gentlemen, let me also go ahead and tell you that if at any point during this proceeding you cannot hear me or hear anyone else that's speaking, please raise your hand. We'll stop at that point, see what the problem is, and then we will begin again. We are conducting this hearing today pursuant to General Statute 7A 49.6, which is the new remote proceeding statute, which became effective June 18th of 2021. And for the record, this court finds that this court and the parties are able to see and hear each other. This court also finds, for the record, that this is a public proceeding that is accessible to the public via a link that has been provided and published by the Alamance County Clerk of Court, and also that this procedure is, in fact, being recorded. Gentlemen, I think we're here for several matters today. Any particular order that counsel suggests the court proceed?
Your Honor, Tony Biller on behalf of Graham, we have filed a motion and calendared a motion to stay the court's June 15th grant of the petition to release the law enforcement recordings. We filed a notice of appeal on June 16th. Reasons alluded to, though not directly stated, perhaps in the brief. We believe that notice of appeal divested the court of further jurisdiction and automatically entered a continuance on all of the pending deadlines. Nonetheless, I have an abundance of precaution, and to in attempt to get ahead of what we were concerned would happen, and in fact did happen, a misunderstanding of the automatic suspension of the production deadlines. We filed on June 16th, I believe, a motion to stay Graham's production deadline. We amended, and Your Honor, we filed on, was that the 30th? There's a memo. We filed a memorandum last Thursday, Your Honor, explicating the basis for the motion to stay. Hopefully you've had an opportunity to review that memorandum. On the 30th, we amended the motion to add Alamance County to the motion to stay. On Tuesday of this week, yesterday, we filed a motion asking the court to revisit its order to modify it at the very end to require, to the extent Mr. Toddy's clients publish the law enforcement recordings, they redact or obscure the identifying information of the police officers, namely blur out their faces, and to the extent they have nameplates or name IDs, just blur those out. As I explained to Mr. Toddy, if that's acceptable by way of between the parties or to the court, we think that ends everything. We dismiss the appeal, we produce to Mr. Toddy, and we go home. A few hours after we filed that motion to amend the court's order, or asking the court to revisit its order, Mr. Toddy filed a motion for show cause based on the Graham Police Department and Alamance County not producing the videos to Mr. Toddy on the deadline set by the court. And with the court's permission, I can revisit, depending on whether you've read the memo, at great length or not much length at all, the reasons why we believe the court should grant our motion for a stay pending appeal.
Well, Mr. Biller, I've certainly read your motion in depth, more than one. Anything you'd like to argue further?
Your Honor, just to highlight something, I don't know how clear it was in the brief. We
Yes,
think
sir.
that the brief is, the motion for a stay is a bit of belt and suspenders. When a non-moving party has a right, such as a relief from a statute, to act in a particular way, parties move a trial court to stay in order, perhaps vacating a statute. In that case, the court has to affirmatively tell the non-moving party, you can't go ahead with what I allowed, pending the appeal. In this case, where the appealing party has the duty to act, in this case, Alamance and the Graham Police Department, we believe it's settled law in this state and under North Carolina General Statute 1-294 that deadline is suspended, provided, of course, that the appeal is directed to the very to the deadline that was otherwise supposed to be acted upon. So again, we think that this motion is redundant to what the law is, but given the public interest and the misunderstandings that may be out there, and in fact are out there now that the order was disregarded, we felt this was a prudent course to take, to ask the court to make it very clear that pending the appeal, this production deadline is suspended. And again, we think that happens independently, and even if it did not, we went further on the laws that where the court can, in its discretion, stay orders. And I think the big issue there is we're just simply asking for the protection of the police officers' identities. There are issues, Your Honor, in the underlying order with which we disagree. Burdens of proof, scope, specificity, and scope of requests. But at the end of the day, the Graham Police Department, and I believe the Alamance County Sheriff's officers, want to accommodate the same thing that Your Honor wants, and that is public disclosure and work for the trust of the public in their law enforcement officers, while at the same time balancing the need of the privacy of officers. And the privacy of officers isn't always an important issue, but it is in cases like this where there is some very charged emotions in the public, and frankly, a lot of misapprehension of what the law enforcement officers stand for. In cases like this, where the officers live in these communities, live in the communities where there's a lot of misunderstanding perhaps of the issues, there's been a lot of spinning in the press, and frankly in some of the pleadings and the lawsuits about what people want and what the law enforcement agencies are attempting. We believe it's more than prudent. In fact, we think it's reflected in your order. There's a real risk of harm here, and a lot of that harm can be avoided by simply protecting the identities of these officers. Thank you, Your Honor.
Thank you, sir. Mr. Toddy, or
Yes,
I
sir.
ask, does, Mr. Albright, do you or your co-counsel want to be heard?
Yes,
You
Your
don't
Honor.
know.
Mr. Pierce is going to lead in.
Yes, Your Honor. I don't know if you want to hear the justifications for why the Sheriff's Department took the actions that it took at this time, or if you want us to reserve that till later.
Let's go ahead and hear it.
Okay. So, Your Honor, in addition to Graham's arguments, which I think we would agree with to a certain extent, that on June 28th, I asked the ACSO, that's the Sheriff's Department, to withhold production of the requested records because Graham had filed its appeal and motion for stay. For the record, the sheriff has not filed an appeal for the order. We're here because of Graham's motion for a stay. So as I understand the matter that's before the court, the newspapers are arguing two issues. One was as to procedural matters, and the other was as the justification for the failure to release. So as to the procedure followed, it was my understanding that Graham appealed and filed a motion for a stay, which was delayed in being heard. I have an email from Adam Banks to Mike Toddy from June 23rd asking about scheduling the hearing on the motion to stay for the week of July 6th. It's my understanding that Mr. Toddy was out of the office and did not respond to the calendar request until after the deadline to produce the records. This is the email exchange as Exhibit C to their motion to show cause. So at the time I made the decision regarding regarding not producing the records, we'd heard no objection from Mr. Toddy to the July 6th date. So as such, it was my understanding that the scope of that Graham's motion to stay was properly before the court, and there was no need for the sheriff to file a separate motion for a stay. If that is not the correct procedure, then I would apologize to the court and make a motion on behalf of the sheriff now for an entry of the stay. To a certain extent, I think we are covered by Graham's amended motion, but make it very clear that we are not seeking to thumb our noses at the court. But I would submit to the court that no party has suffered any prejudice by the procedural shortcomings since the intent to appeal the court's order by Graham has been known almost since the order was entered. The parties were engaged in discussions about scheduling this exact hearing, and it's completely foreseeable that the parties would seek entry of the stay. So as to the justifications underlying the request, I would suggest that the interests at issue here more than justify proceeding with caution. To start, I'd like to call the court's attention to the original petition. The petition filed by the newspaper seeks the release of all law enforcement and other recordings leading up to, during, and after the I Am Change March occurring on October 31st, 2020. So to be clear, the newspapers made one request for one set of recordings. It was made at one time in one file number. So from the very beginning of this action, the petitioners have acknowledged that there was a single event captured by multiple cameras. They don't seek specific records from any law enforcement agency. Rather, they seek every bit of footage from the one event. The event is the important aspect here, not any particular recording of the event, because the petitioners do not identify any specific recording they would like to be produced. So after that hearing, the court entered one order covering all of the records. The order does not specify the records held by either agency. Instead, the order concerns itself with all of the records from the single event. Each of these recordings is a different view into this single event. These recordings are thus inextricably linked. They are each part of the request and cannot be separated from one another. Even the petitioners seem to acknowledge this, since they do not identify any particular record as being more important than any other. So given the nature of the petitioner's request and the nature of the recordings, the ACSO's release of their portion of the videos could be prejudicial to Graham's appeal and could frustrate the purpose of the appeal. Release would constitute irreparable harm to Graham and the interest that the city is seeking to protect with its appeal, because these videos cannot be unreleased once they are given to the newspapers. Once they're out, they're out. They will be widely distributed and widely viewed. There is no way to fix an untimely release should Graham prove successful in its appeal. These are factors that merit in favor of caution. So given the risk of harm and the fact that this motion for a stay was pending and soon to be heard by the court, I thought it most prudent to withhold release of the recordings until the court had ruled on Graham's motion. So at the time I made the decision, I had heard no objection to a hearing date during the week of July 6th. Did not advise my client not to release the records out of a disregard for the matter, but instead a deep concern to cause the least amount of harm to all parties. It seemed most advisable to me to allow the court to render its decision on the motion rather than releasing the records and potentially committing an irreparable harm. And as we stand here today, the ACSO has the recordings prepared and ready for release, pending the outcome of this hearing. So thank you very much, Your Honor. I just wanted to explain to the court why the ACSO felt that we needed to have this hearing before we release the records.
Mr. Toddy, I'll hear from you, sir.
Thank you, Your Honor. As we started at the beginning, we represent 7 newsrooms and operations within the state of North Carolina, which is a mixture of newspapers, broadcasters, and an online publication that's available and targeted statewide. This matter stems from our clients, the petitioner's January 5th, 2021 petition for release of law enforcement recordings of events taking place on the public streets, sidewalks, and property of Graham, North Carolina on October 31st, 2020, pursuant to 132-1.4G. After a full and complete hearing on June 10th, the court entered an order on June 15th requiring complete unredacted release of the requested recordings by 2 p.m. on June 25th, which was a Friday. The respondents have not complied with that order whatsoever. In particular, we are here on Graham Police Department's motion to stay the enforcement of the June 15th order requiring release by 2 p.m. on June 25th, as they originally filed it on June 25th. And their amended order seemingly to include the Alamance County Sheriff's Office and Sheriff Terry Johnson, separate custodial law enforcement agencies, but to include them in their stay. Neither their order nor their motion nor their brief, their amended motion or their brief, cites any authority for their standing to do so. On 1 July 2021, Graham Police Department served their memorandum in support of its motion to stay release of the subject recordings pending appeal. As will be discussed further in a moment, it is filled with assertions of fact that are not before the court in any way. It attempts to re-argue repeatedly the petition that this court has already ruled upon, and it seeks to mislead the court by attaching the filed version of 2015 House Bill 975 and not Session Law 2016-88, which was the result of 6 additions or revisions in the legislative process, stemming, I believe, more than a year, and suggest that petitioners sought release pursuant to 132-1.4A-F, which is the authorized people who are in the video who are able to seek disclosure or release. We have not done so. We've not ever suggested that we're doing so. We have only moved under subsection D. In summary, Graham Police Department's memorandum is a grab bag of multiple assertions seemingly offered in the hopes that one of them might stick to the proverbial wall, and none should. As has already been acknowledged, Sheriff Johnson and the Alamance County Sheriff's Office has not appealed the court's ruling. Sheriff Johnson and the Alamance County Sheriff's Office has not moved to stay enforcement of this court's June 15th order. and Sheriff Johnson and the Alamance County Sheriff's Department has not complied with the June 15th order whatsoever. Yesterday, and I believe Mr. Biller was wrong in his timing, we filed our motion for an order to show cause. That was filed roughly before 3 o'clock, and about 4 o'clock, we got the joint motion from the respondents to amend the order to blur the names and likenesses of the officers involved. Your Honor, that was before you on June the 10th. It was argued to you on June the 10th, and that ship has sailed. The respondents Grand Police Department and Chief Cole indicated in their memorandum that they produced more than 50 hours of recordings. I've done, as I said to you before, more than 35 of these, and I have been involved in situations where the blurring must be done in a hospital room or a particular person that is on the scene that's a child at an officer-involved shooting or things like that. And to suggest that that effort in more than 50 hours of recordings would be minimal is laughable. It would take tens, if not 20s, if not hundreds of hours to do so, to comply with such an order, and I believe I argued that to the court. Moreover, given that all of this took place on the streets and sidewalks and public areas of Graham, North Carolina, and I know I argued this before, there was no expectation of privacy whatsoever on anyone involved in the public streets, whether they were part of the march, the police officers or other law enforcement, or people just happened to be looking at what was transpiring. We have no issue with the notion that generally this court has the ability to stay these matters pending an appeal. First point on that, and Mr. Biller did not mention it, under GS 1-294, the automatic stay that he's talking about is upon perfection of the appeal. The appeal has not been perfected. The transcripts are not available. They've not been provided. A proposed record on appeal is not provided. Thus, this court has jurisdiction. Mr. Stevens, who's also on the line with us, and I cannot think of another circumstance where a public agency has argued that the mere notice of appeal stays their obligation to perform as the court has ordered, absent the entry of a stay, alleviating them of their obligations. That just simply hasn't happened here. The fact that the court has discretion, and it's the exact same discretion that the court ruled on under 132-1.4 AG, that your decision on a stay will not be disturbed absent a showing of abuse of discretion. That's in the Park East sales case, which is at 186 NC App 198, and that the progeny for that can be found in the Home Indemnity Company versus Celanese case at 99 NC App 325, and Motor Inn Management versus Irwin Fuller Development Company at 46 NC App 707. I believe I got the previous site wrong. It's 99 NC App 322. In any event, the cases that I've put forward for you will show that absent a showing of abuse of discretion, your decision not to enter a stay will not be disturbed. GPD has not perfected its appeal, and is evident by the authority that they cite in their own memorandum. This court is free to address the matters that are before it. Your Honor, we believe it's absolutely improper to use this proceeding on a stay to re-argue the petition. Throughout its memorandum, the Graham Police Department raises issues not put before the court during the hearing on June 10th as additional reasons against release. Similarly, the memorandum again takes issue with the breadth of petitioner's petition, which was previously argued not only on June 10th, but also on March the 4th. And a plain reading of 132-1.4 AG requires the petitioners, my clients, to identify the recordings they're seeking with reasonable particularity so that law enforcement can identify those recordings. It is axiomatic that we have no capacity to identify particular recordings, particular events, particular officers in recordings that require a court order for us to see them. That would be absolutely inconsistent with the way this process is supposed to work. In any event, these arguments are not properly before the court on a motion to stay, and we believe they should be disregarded in their entirety. Also new in their memorandum is this public policy argument, which is at pages 1, 2, and 9 of their memorandum. There they assert a newfound public policy argument not raised at the hearing on June 10th. In petitioner's view, this is again an improper attempt to re-argue the petition and not what GPD's motion requested. In support of this contention, GPT asserts a public policy argument not found in 132-1.4a or in Session Law 2016-88, and the selected truncated excerpts from the press release issued by the governor that are attached to the memorandum don't do it any service as to make those points. That is, Your Honor, I want to make it clear. They provided you with a copy of the original bill that was introduced in the House that went through 7 iterations and multiple amendments before it was entered. And the preamble that is listed in what they attached to you is not the preamble to Session Law 2016-88. Your Honor, I invite you to look that up yourself, and if you want to see it, I can pull it up on the General Assembly's website. But there was an enormous amount of back and forth and editing in this, and I think it's a misnomer to suggest to you that the public policy now espoused after the hearing on June 10th should be considered in connection with a motion to stay. At pages 2 and 12 to 13 of their brief, GPD asserts a new argument on irreparable harm without any recitation of competent evidence or authority. That is, officers will suffer unspecified irreparable harm should the recordings be released. Again, and we've discussed this before, all of this happened in public in Graham, North Carolina. It is also important to remember, Your Honor, that not a single Graham Police Department officer appeared or asked to be heard at the hearing on the petition on June 10th, as was their statutory right pursuant to 132-1.4G and this court's order from March 15th, 2021. Rather, it appears that not having prevailed in its efforts to prevent release of the recordings, Graham Police Department now asserts irreparable harm and privacy arguments by proxy on behalf of Graham police officers who failed to appear and raise those arguments with the court back in June. At page 10 to 12 of the memorandum, Graham Police Department raises matters which are not before the court, and Graham Police has not put on any competent evidence of the assertions made in those arguments.
Like every time you said that, that doesn't quite jive. All those arguments were made.
I'm sorry?
Whoever's speaking needs to be quiet while Mr. Toddy finishes. Please go ahead, Mr. Toddy.
Thank you. Moreover, Graham Police Department's contentions are again an improper attempt to re-argue the petition, which is not before the court. Graham Police cites no authority that would compel this court to stay its order of release owing to the possibility that the same materials may be discoverable in federal court matters. They certainly raised the issue before you on June 10th. They've cited no authority that you must follow that requires a stay be imposed here. Also at pages 12-13 of their memorandum, Graham Police Department purports to assert standing to seek stay of recordings that Sheriff Johnson and the Alamance County Sheriff's Office have been ordered to release. Again, Graham Police Department cites no authority providing it with authority to stay release by a separate custodial law enforcement agency, and none exists. To this date, until Mr. Pierce spoke a few minutes ago, Alamance County Sheriff's Office and Sheriff Johnson have not moved to stay this proceedings, and we believe to do so here at the 11th hour is inappropriate. This court should deny GPD's motion to stay release of the recordings by Sheriff Johnson and Alamance County Sheriff's Office for that reason alone. Additionally, release of the recordings does not necessarily negate Graham Police Department's ability to appeal the court's decision. Mr. Stevens and I have been involved in multiple open government matters where the disputed documents or meeting are eventually revealed pending appeal, and yet the appellate courts have applied the doctrine of capable of repetition, yet evading review. There's no reason that I can think of that wouldn't be possible here. To the extent that Graham Police Department seeks an injunction to prevent the release pursuant to Rule 62, none of the predicates for an injunction are present, including a sworn statement, proper notice, and that sort of thing. And I've discussed this already, but at pages 13 and 14, for the third time, Graham Police Department improperly argues that there's something incorrect with the petition or the amended petition. The argument was made on March 4th and on June 10th. The plain language of GS 132-1.4 AG requires the petitioner to identify the activity contained in the recordings sought sufficiently to identify those recordings, as is evident from Graham Police Department's April 23rd submission to the court and to us, and Alamance County Sheriff's March 18th submission to the court, and later submission on June 9th to us. They were able to do that based on that description in the petition. The parameters suggested by Graham Police Department are nowhere to be found in 132-1.4 AG or otherwise, and petitioners were and are under no obligation to identify specific officers, particularly into events or recordings, etc., in the recordings that require court access to review via the statutory disclosure and release process. Moreover, Graham Police Department complains that it was required to follow the process set out by the General Assembly in 132-1.4a, including giving notice to law enforcement officers appearing in the recordings of the time and the date of the hearing and their opportunity to be heard. That is what the statutory process requires. That's what this court's March 15th order requires, and that's what has to be done in order to make the pot right for you to have decided this matter back on June 10th. Again, Your Honor, to the petitioner's knowledge, not a single Graham police officer appeared to protect their purported privacy interests and concerns of recordings made in the public streets, sidewalks, and property of Graham, North Carolina. Lastly, Your Honor, Graham Police Department at pages 14 and 15 of the memorandum attempts to create an issue where none exists about burden shifting. At the June 10th hearing, I argued that by operation of 132-1.4G and the court's order of production for in-camera review, and the fact that the same recordings are likely relevant to several criminal matters pending and or dismissed, that the recordings are judicial records that cannot be withheld or restricted absent a showing of a compelling governmental interest. It was my understanding when you remarked those words in your ruling from the bench that that's what you were addressing. You can see our arguments on those points at pages 9 to 11 of our March 5th memorandum in support of the release. Graham PD's final argument, final point at the hearing on June 10th, and the court, Graham Police Department argued this final point at the hearing on June 10th, and the court, after weighing the statutory and other factors, employed its statutory discretion to decline Graham Police Department's argument. No stay should issue here, Your Honor. Certainly not one as to the Alamance County Sheriff's Office or Sheriff Johnson. It's been 249 days since the march took place. It's been 183 days since the petitioners filed their petition. It is past time for these recordings to be released. With that, Your Honor, unless you have any question, that concludes my prepared remarks.
Mr. Toddy, Mr. Beller, I'll give you an opportunity to respond.
Thank you, Your Honor. Number of points. The Graham police officers were not represented at the hearing. That's just simply not true, Your Honor. We represent the Graham Police Department to include its individual officers. There's no requirement in the statute that officers need to come up separately represented or separately to testify. We speak on behalf of the police department and its members filmed. I mean, that's just not a meritable argument. As far as a grab bag of legal theories, 1-294 does say when the appeal is perfected, but I don't think anybody sitting here today believes that is a hurdle to be overcome. That is a procedural requirement. When the courts address that, the stay relates back to the time the appeal was filed. That's again, that is a ticky-tack argument that I don't think justifies claiming no stay is appropriate or imminent. To Strong's NC Index, 4th edition for appeal and error, section 220, a trial court is considered functus officio while an issue is appealed to the Court of Appeals. And the trial court is generally without jurisdiction to issue an order in the case while the appeal is pending. That's not a grab bag. That's just fundamental North Carolina law. A sister court, I believe it was the North Carolina Business Court 2019, cited in our brief. North Carolina law has found that 1-294's automatic stay stays deadline contained in orders. In Red Valve Inc. versus Titan Valve, number 21CVS15 2019, Westlaw 78975, again, cited in our briefs. This isn't grab bag. This is fundamental North Carolina law. Loader versus All-Star Mills, North Carolina Supreme Court decision, 301 NC 561 at page 582, 1981 decision. stating that orders entered on the subject matter of the appeal following the notice of appeal must be vacated. So this isn't a grab bag. And then to stand up and argue that law enforcement officers have no recognizable privacy right here warranting protection. Again, he cites, well, that's not the immediate legislative history. You're citing the original legislative history when this was introduced. Again, that's just not a serious argument. And even if one wanted to stand behind these frivolous technicalities to avoid protecting, all we're talking about is protecting the privacy rights of these officers, one need go no further than this court's order. Checking the box. Release would reveal information regarding a person that is of a highly sensitive personal nature. I don't believe my colleague would say that has nothing to do with privacy rights. Or the next box this court checked. Release may harm the reputation or jeopardize the safety of a person. Again, Your Honor, it is not credible to hear the attorney for these press agencies argue that the law enforcement officers simply have no privacy rights. It flies in the face of the legislative history. It flies in the face of this court's order. And it's unfair to these officers, and it's legally without merit. My colleague says that we repeatedly attempt to re-argue the merits of the case. Your Honor, the only reason we attempt to re-argue the merits of the case is not for purpose of trying to get you to change your mind. Mr. Toddy is correct, I think, as he put it, that ship has sailed. But there are three different avenues that this court can recognize that the deadline to that order is stayed. The last is the discretionary path that a court can, in its own discretion, stay the deadlines for its orders. There are three components as laid out in our briefs to a discretionary stay, one of which is the merits of the appeal. So while we did raise our disagreement in what we plan to argue on appeal, it wasn't for purposes, contrary to what Mr. Toddy says, it wasn't for purposes of arguing with you about the order you entered. We agree with Mr. Toddy that that is done. It was for purposes of forecasting that this isn't a frivolous appeal. There are real rights here. Mr. Toddy is correct that the issue may not be moot on appeal, but the officers' rights to protect their privacy in very contested issues in the local community will have been lost. That is harm, Your Honor, and that is irreparable harm because it can't be taken back as the attorney for ACSO said. Once those videos are out there, the harm is done. It cannot be repaired. And again, we've offered a way through this, produce them during the pendency of the appeal, subject to the blurring. We'll probably dismiss the appeal. Mr. Toddy says, well, there's 50 hours of footage. That's too much work. There's nothing saying they have to produce all 50 hours of the footage. I think by any accounts, the issues that his clients have reported on are confined to minutes. I think all the time in total is about 30 minutes for the relevant disputes and what has given rise to his clients publishing. That's not 50 hours. That's a few minutes. So again, I think that's overstated. So, Your Honor, I think we're on very solid grounds for believing the deadlines are stayed, or at least stayed once the docket has been entered by the Court of Appeals, and this court has ample discretion to protect the privacy rights of the officers by amending its order or barring that, staying the implementation of the order or the deadline pending the appeal. Thank you, Your Honor.
Thank you, Mr. Buller. Mr. Pierce, anything you'd like to add, sir? Mr. Pierce, would you like to be heard?
Yes, Your Honor. Can you hear me?
Yes, sir.
Okay. Just to be clear, the sheriff is here because we view these records as being inextricably linked, the sheriff's department's records and recordings as being inextricably linked to Graham's, since they're just different camera angles of the same event. And it was our concern that since this motion was pending, if we released these records, that it could frustrate the order of this court, frustrate Graham's appeal, and perhaps cause the irreparable harm to Graham's appeal. So that's why we wanted to give this court the opportunity to have this hearing before we release the records. So we stand by to release the records or not release the records as this court determines now. So thank you very much.
Yes, sir. Mr. Toddy, go ahead.
Your Honor, it was not my understanding at the hearing before you that Mr. Banks was representing the Graham police officers. If that's the case, then they've had their shot at this in their privacy interest and apparently permitted Mr. Banks to argue that. You'll recall at that hearing that one of the arguments Mr. Banks made was there are already a bunch of videos available of this, and so they don't really need these. And that cuts against these arguments of great privacy and you can't unring the bell and inextricably intertwined if they're already available. It is also my understanding, Your Honor, that third parties that are criminal defendants, either pending or dismissed, have these recordings or some of these recordings in their possession, and they're not restricted in their use of those particular recordings. To prevent the petitioners who followed the process to get these recordings, which you agreed to release or needed to be released, to stall that strikes me as what my friend George Daniel in Caswell County would say, that it seems to me to be a bit of slow walking. We don't believe this appeal or any appeal on your exercise of your statutory discretion has any merit whatsoever. If they were there representing the Graham police officers that they're now talking about at that hearing, they had their shot, you applied the factors, and you ordered the release without redaction. To create an issue where there isn't one doesn't create a meritorious appeal. We certainly do not believe that the Alamance County has any, Sheriff's Office or Sheriff Johnson has any leg to stand on in not doing anything other than deciding on their own without interaction with the court that they didn't have to comply with this court's order. We believe they did. Perhaps Graham Police Department has a bit of a leg to stand on, but both my partner Amanda Martin and I wrote to counsel for the respondent saying, aren't you all in violation of the court's order? And we didn't get any substantive response other than, well, the motion hasn't been heard. And as is attached to our motion to show cause, Ms. Martin said, but aren't you in violation of the court order? And we didn't get a response. I was on vacation that week, a well-earned vacation to a place that did not have a lot of connectivity. And Mr. Banks knew that. He got a bounce back from me. To say that there was no objection or concern raised is just inapposite given what the communications that are in front of you that were made by my partner Amanda Martin prior to my return from vacation and me the first day I got back. Your Honor, this has gone on long enough. If they've got meritorious legal arguments, they can proceed with their appeal, but there is no reason to stay the release of these records. My clients have paid us to do this. You've seen fit to release them, and we would ask that you deny the stay and deny the alternative motion to stay your order denying the stay pending the Court of Appeals Act.
All right, thank you, counsel. Council, as you all know, this court has spent many hours and given great consideration to this case. And this hearing today, in preparation for it, is no different. One of the that if you do the next right thing, you'll end up in the right place. And the one thing we want to do here is try to get this right. And in that vein, your motion to amend the order that I entered is denied. That ship has sailed. The motion for the amended motion for a stay is allowed because this court is divested of jurisdiction with regard to all matters embraced within or affected by the order, which is the subject of the appeal. Further, this court is of the opinion, well, strike that, the motion to show cause directed at the Alamance County Sheriff is denied. That's the order of this court.
Thank you, Your Honor.
Someone will prepare an order, Mr. Biller, and please circulate that to Mr. Toddy and Mr. Pierce and present that to me for my signature.
We will do, Your Honor. Thank you.
Your Honor, just to be clear, I believe that technically the motion to show cause was directed at all respondents. I'm assuming the entire motion is.
Yes, sir. And
Yeah.
yes, to be clear, it is denied as to each respondent.
And Your Honor, does the amended motion encompass the sheriff's department so that we're not releasing these records until Graham's appeal is finalized?
There's one order. It has been appealed. Let's see what the Court of Appeals has to say about what happened.
Thank you, Judge.
Thank you, Your Honor.
Yes, sir.